So a real question will be whether evidence is, or whether opinion evidence is something that is lay evidence, which is when someone sees something and is describing it. That's at the end of the day, that's what lay opinion evidence is. You saw something and you're describing it using words that involve your characterization as a regular person who, just speaks in terms of categories that we all use: fast, slow, heavy, slight, um, wet, dry. These are all, no one who says, oh, a towel is wet talks about the parts per million of hydrogen and oxygen that are contained within the fabric of the towel. That's not the way ordinary people communicate. But yet, when you say something is wet, you are offering a characterization. You are, in your mind, saying that the water content of this towel has risen to such a level that I and most everyone I know would regard it as wet. So when is your opinion something that has drifted into something that depends on expert knowledge? So I think I told you the story of when I was sitting in the movie theater studying for the bar, and in Time to Kill, they offer that prior conviction by one of the expert witnesses, and I couldn't restrain myself, and I spoke out objection in the middle of the movie theater. That's not something, if you had polled the moviegoers coming out of there, they wouldn't have said, I think Matthew McConaughey should have objected to that. That's not something within the knowledge of someone who's not been to law school. Yet it was my immediate reaction to something I actually saw. But even though I was responding to what I saw, mine was not a lay opinion. Yeah, I don't want to say it was an expert opinion, but it was something that depended upon specialized knowledge that I spent 3 years of my life collecting. So, so you have to distinguish whether something is an ordinary response to stimuli, an ordinary description of something that is within the ken of ordinary folks walking around who know basically what all of us know. Or is someone saying why that looks like a particular type of bird and describes it using the genus and species name. If they're doing that, then what they're doing is they're bringing their expertise to an on the scene observation. In that person's opinion, this is a bird that has a particular genus and species name. There's a great episode of Big Bang Theory where you had the cricket expert who tries to determine whether this is a particular type of cricket or not. Well, if you're saying this is a cardinal or a bluebird, that's within all of our sources of knowledge. But when you're starting to drill down, even though you are describing something, your opinion of something, this is something that may not be kind of walking around knowledge for everyone else. So in Ragland versus State, we're asking the question of whether something is in the category of ordinary knowledge that people have. It's a fast car, it's a slow car. Even if we would all disagree on the definition of fast or slow or heavy or light, that the question we have to raise in Ragland is whether the witness who sees something and offers his or her opinion on what that is, whether that is based on particular specialized knowledge or not. So in Ragland, you had the prosecution setting this up very nicely to make the determination, because prior to asking these officers what they saw, they asked the officer, do you have training in the investigation of narcotics cases? Yes, I do. I went through this school, this was the instructor, this was his background, etc. Now, based on that officer, one of the questions said, based on that officer, what do you think you saw? And he said, I think I saw a drug transaction. So the problem here is as you note in the case, it's a question of whether the prosecution has properly set this up as as an expert testimony. In order to do so, there are certain rules that require, in state and federal court, require you to provide notice of your intent to use an expert and any reports, et cetera, that the person's going to rely upon. But you've got to give notice that you're going to be using an expert. And that was the issue in this case. So it may not matter in a lot of cases whether we regard this as expert testimony or lay testimony, except to the extent that unless it's relying on expertise, it has to be an observation by the person. You know, this is a heavy car. This is a fast car. I watched it zip by me. You know, if you didn't watch it zip by you, you wouldn't know one way or the other. If you just watched a videotape and they said, is that car moving fast, in your opinion, that doesn't help the jury. The jury can watch the videotape. But we care whether it's lay or expert for that reason, because an expert can comment on things that he or she doesn't personally see. You know, Mr. Expert, if I told you that a person's heart rate was 52 and her blood pressure was, 81/30, what would you tell me about that person's health? The expert doesn't actually have to feel the pulse or take the blood pressure. The expert can comment on things that are related to the expert and give a medical opinion, give a scientific opinion. But a lay expert, and because we've talked about the lay expert is really just speaking in shorthand when the lay expert uses opinion characterizations. So we care for that purpose, and we care for the question of notice. So it does matter which of these two categories something fits into. And in Ragland, the court holds that even if you're making an observation, if your ability to draw an opinion based on what you're seeing depends on specialized training, in this case, the narcotics training, and there are courts that will allow expert opinion on narcotics trafficking and allow these sort of conclusions. But they have to be based on expert opinion, not lay opinion, at least the way the officer was setting these things up. And in fact, if the person didn't have expert training then and didn't have insight because of his or her profession, there would be no benefit to the officer saying, yeah, I see that looks like a drug transaction to me. The only reason the officer would have greater insight on that than the jury would be if there was specialized training, which would then put it in the category of expert opinion testimony. So two big takeaways: the lay opinion, fast, slow, heavy, slight, etc. Those things have to be things that are actually witnessed, seen by the witness who's now on the stand, who we can cross-examine about, what does heavy mean to you? What does fast mean to you? The expert, however, has to be qualified as an expert. It has to be within, the opinion he or she's offering has to be within the realm of his or her expert training. And the expert can comment on information that's related to the expert. If I told you the following facts, in your expert opinion, what could you conclude? Lay opinion is just ordinary parlance, basically, ways of describing things. Expert evidence is taking some specialized bit of knowledge and applying that specialized bit of knowledge either to something you see, as in the case of this drug transaction or alleged drug transaction, or something that is related to you. Either work. In some ways, lay opinion and expert opinion are completely unrelated concepts. One is just a way of describing things that we all see, lay opinion. The other is about taking specialized knowledge and applying it to a set of facts, regardless of whether you've seen those facts or they're simply related to you, either prior to the trial or, in fact, at the trial itself.